loose ends that were left from our last, from the successful work on House Bill 2460B. I thought that what we could do is just quickly introduce ourselves as task force members. Some of you have worked together already. I'm new to the task force, so I can start. I'm Mary James. I'm a senior judge out of Marion County, and I work kind of all over. I don't have a lot of experience with justice or municipal court, other than, you know, a traffic ticket a number of years ago. But I did take some appeals from those courts as a sitting trial judge. So I'm very excited to be able to help facilitate progress on the 6 or so remaining issues that we've been asked to look at in the next 8 to 10 months.
Why don't I go through, because screens can move around, and I'll just read off of my screen. Judge Britton, I think you're next.
Good afternoon. I'm Juliet Britton. I am presiding judge at Beaverton Municipal Court. I'm really here, though, in my capacity as the Oregon Judges Association president. A lot of what we're going to discuss is for courts that are not courts of record, and I have a court of record. So most of the stuff we're talking about doesn't apply to my court. If we need kind of more specialized municipal judge experience, I can pull in some other judges. A lot of them didn't have the time commitment availability. But glad to be here.
Thanks. Kara?
Hi, everyone. I'm a research assistant for the Oregon Law Commission. Now some of your faces are familiar to me. I've really been enjoying my work with Amy, and I'm excited to support this work group going forward.
Jim?
Jim Nass. In the proposal, there was a reference to the appellate commissioner for the Court of Appeals in 2015 proposing this work group. It's only taken a few years to get it going. And I was on reviewing House Bill 2460, reminded what a tremendous amount of work this work group has already done. And so I'm looking forward to looking at the additional issues that we weren't able to reach last time. And I'm especially pleased that Judge James has been able to join us, because one perspective I think we were missing last time around was a circuit judge who had actually heard appeals from either a justice court or a municipal court. So I am looking forward to whatever insights Judge James may have.
Thank you.
Melissa?
I'll try not to disappoint, Jim.
Melissa Franz. I'm an assistant city prosecutor for the city of Eugene. I've worked in this capacity since 2019. I worked for OJD as a legislative analyst and participated on the 896 bill back in 2017, and then participated in this group since the last group since the inception. I wish I could say that makes me an expert, but it does not. I will leave that title to Jim.
Monty?
Hi, my name is Monty Ludington. I'm a senior deputy district attorney here for Lane County, here in Eugene, Oregon. I have also been a prosecutor for about 16 plus total years, but I also spent about 3 years as a municipal court judge in a non-court of record, and here on behalf of ODAA.
Thank you. Kimberly?
Yeah. Hi, everyone. I'm Kimberly McCullough. I am Senior Counsel for Government Relations at the Oregon Judicial Department, and glad to be back with y'all here.
Lindsay?
Hi, everyone. My name is Lindsay Detweiler. I'm an attorney in the Office of General Counsel at OJD. And I am also glad to be back working on these last issues and was involved in the first version of this work group just for the last 2 years.
Jessica?
Hi, everyone. My name is Jessica Menifee. I am an attorney at the Office of Legislative Counsel. I worked on 2460 as the drafter, but of course, I have to give a lot of credit for the initial drafting legwork, which was done by Jim. I also was working on the original Circuit Court Appeals Law Commission project. So I think for me, Jim, and it sounds like Melissa, this is like year 10 of appeals work groups. So I'm happy to be back.
Dan, Judge Cross, excuse me.
Well, you're fine. They say call me Dan, and holy cow, we're not in court. My name is Dan Cross. I'm the Washington County Justice Court Judge, where I've been for about 9 years now. And I also think I was for this work group on 2460. I think I was there at the start or darn near right after, in the baton march to the passing of the bill. So I'm looking forward to addressing what we got left. And I'm here, now I'm not only Justice of the Peace, I'm also I chair the legislative committee for the Oregon Justice of the Peace Association.
Thanks. Ami?
Hi everyone, my name is Ami. I work for the Legislative Policy and Research Office as a legislative analyst. And I'm swapping spots back from Chris, so I'm happy to be back. Nice to see everyone.
Judge Jumper?
I think you're muted, Judge Semper.
Yep.
That's better. Oop.
Can you hear me?
Yes, now we can.
Okay. Hi there. I'm the presiding judge out for this in the city of Bend, and I was on the last appellate work group, and I'm just happy to be back.
Thank you. Matt?
Hey there, this is Matt Shields over at the bar. We are super interested in what direction this goes in. So you'll probably have me or Avery back and forth at these meetings, and we are happy to help out in any way we can.
Thanks, Matt. And Rep. Wallen?
Hi, good afternoon. I am Representative Wallen. Kim Wallen. I'm from Medford, and I think I'm here because I like all of the topics of Court of Record and Appeals and all that is interesting to me. So I'm a lawyer, but I'm sort of got brought in for this other discussion, which ironically was brought up by the cities, because I think it's the cities who are going to be the biggest opponents of this idea, but also there are cities who are concerned about the qualifications of the judges, the justices of the peace, the municipal court judges, because they're not required to be lawyers, and they're not subject to the Judicial Fitness Commission. There's not really any oversight other than the council that appoints them in the case of a municipal court judge or the voters. But other judges are required to be lawyers. So that question, I already know the Justice of the Peace in my county is not happy about even having the discussion about this. But he's a lawyer, so I don't even know why he's frustrated by that. So anyway, that's my issue. That's why I'm here, and I'm sure we'll have a robust discussion about it. Thank you.
Thanks, Rep. Wallen. I'll do two things. One, I'm Amy Zebko. For those of you who I haven't met, but I think I've met all of you at this point. I'm the director of the Oregon Law Commission, and I'm thrilled that you will, so many of you are back to continue this conversation, and welcome to the new folks. I want to let you know that there are a handful of folks that have expressed interest but couldn't make it today. So I'm going to be sending out a roster at the end of this, and happy to talk about that further, but just wanted to flag that this is a beginning group, but we have some more folks that just couldn't make it today. So Judge James, I will pass it back to you. And I'm happy to go either way.
Okay. I think that I'm going to have you actually talk about the process. Okay. And I will tell you that Amy and I and Melissa had it, or no, not Melissa. Let me find you. Jessica had a chance to talk about just some of our process, because there are 6 primary, I guess, points of interest that we've been asked to take a look at. And then there are a couple of additional ones that have come in kind of from the side, that we may or may not get to, and we can talk about whether we want to take another look at those as well. But there are 6 that were kind of like, they were kind of put on the wall and then we didn't get back to them, or we weren't able to resolve them just because there were some, I understand, some different approaches that people were considering, and we didn't have time to kind of wrap those up. Some of them seem to be, and these may be prophetic words that I eat, but some of them seem to be a little bit like low-hanging fruit, and we could maybe address them and resolve them in the near term. Some of them look like they're going to take a little bit more digging and maybe some subgroups. So keep that in mind in terms of your particular interest areas on the items that continue. And a couple of them, I want us to kind of to take a look at, but I think we also might have to decide whether they are actually within our the scope of our responsibilities, and whether we have the right people at the table and in this work group to actually be able to decide them, or whether they take a completely different group of stakeholders. Because I don't want us, delving into things where we really don't have the people in the room that need to be able to weigh in and on whom it may have the greatest impact. So those are kind of my introductory remarks about the task ahead, but I'm gonna let Amy then talk to us about maybe the process and how we hope to proceed in terms of moving forward. We also have some fairly strict timelines in terms of the work that we're trying to do, and in terms of when we could potentially get that in front of the legislature if we decide to have concrete proposals. So I want us to be mindful of that. I know that the last kind of the journey up, some of you have mentioned the 10-year march, and I know that is accurate. I also know that that we don't have 10 years for the next phase. So and so I want us to be mindful of what we can actually accomplish, and not spread ourselves too thin.
Thanks, Judge James. So most of you have worked with the commission before, or I've talked to you in the last few weeks. So I will kind of hit the high level things that I wanted to talk about. And if anyone has any questions, please let me know. This group, as we all know, came from 2460, so we are lucky that we have had a fair amount of thought in this group that's already been done on a number of these issues, and there's already been preliminary conversations about a lot of this information that we're going to be wrestling with, which I think is great and helpful. The work group in general, I think Judge James mentioned something about small groups just a moment ago. And I'm welcome any sort of feedback, but it seemed to me that the group last year really hit their stride when they were able to use that small group process and really kind of wrestle with some of those issues that got really thorny, because this is a really technical group, and kudos to all of you for caring deeply about where the commas go, but that is a part of this conversation, and that is especially as someone who does not practice in this area, there's a lot to learn, and you guys are definitely the certified smart people who know this area of law. We are going to meet on a monthly basis with the caveat that if things get complicated or we are running into a deadline, we'll go up again to twice a month. So that's part of it. And I will be reaching out to all of you probably on Monday with here are some potential dates going forward from now until the end of August of 2026. The meeting materials will be posted 2 weeks in advance with the caveat again of if we're going to meet every 2 weeks, it won't be 2 weeks in advance. I'll do my best to get the information out as quickly as possible. All the recordings will be posted. So you guys, if you miss a meeting, you can go in and watch those recordings. Kara is also here to help us. She's going to be keeping meeting notes and we're going to write those up together. That was one thing that we didn't do as much last time around, especially the last push, and I think that will be helpful for you. The recordings are the decisions, but the meeting notes will just be a cliff notes for you all to be like, oh yes, on such and such a date, we talked about this issue. And here it's kind of the tenor of the conversation. I shared a memo with you all that has historically been shared with work group members at the beginning of every work group. I'm not sure if it happened 5 years ago or not, but if it has, then you're seeing it again. And if it hasn't, please take a look at the memo. We are, as you know, we're looking for your best knowledge and understanding as a certified smart people in the room. And you guys have a wealth of experience and we look forward to relying on that and appreciate that that's what you provided last time and hope that we can continue that again. And I very much enjoyed working with you guys for the first 18 months of my time at the commission. So I'm looking forward to that again. I'm available for questions anytime that people have issues. Materials will be posted on the website. And so you'll be able to get access to everything. All of our meetings will be over Zoom. So again, just like last time. And I think that's it in terms of come be ready to talk about things. If you want to write things, I know that we did a lot of memos, trading back and forth and propose language last time around. And if that still works for folks, I think that sounds great. And I'm happy to distribute what you would like to distribute. Does anyone have any questions? Great, thank you.
So a couple of things. Amy we had talked about the idea of the memos, and I thought that would be particularly useful for the small groups on the specific topics. If we could get kind of executive memos, that tell us sort of what you discussed, if you came to recommendations, that you could list them out and we can then have a heads up about it. And then that way because Amy would be distributing those in advance of the meetings, we wouldn't have to kind of rehash what you discussed in your committee in order to get to this committee. I'm mindful that my suggestion is that if we can, that we meet at the noon hour. And we had been looking at Tuesday or Wednesday as optimal days. I'll have Amy send something out, but I selfishly asked for Wednesdays, but that's just because of my own schedule. But we can work with whatever the majority would like to do. I'm also mindful, having just returned from the judicial conference, that we were talking about work and health balance, and people were like, how are we supposed to have a balanced life when all of our meetings occur at lunchtime, when we should be getting out there and walking and doing things like that? And so I would like our meetings to be 1 hour and not longer than 1 hour, if we can do that. And that's where I think the written preparatory materials can be so useful, because then we can find all of our other free time to read those memos and be ready for the meeting. So I thought it might be helpful to just identify the issues that were asked to address, and then open it up for any conversation about those issues. You know this much better than I do, but just to summarize, the work group identified some issues that they wanted additional analysis of. One of them was the limitations on appeals from municipal offense convictions. One of them was whether violations appealed from the local court to the circuit court and then to the Court of Appeals should proceed under ORS Chapter 19 or Chapter 138. And if there was a way to figure out an easy kind of Gantt chart that tells us how, you know, if this, then this, for litigants, so that litigants aren't as confused by how to proceed, if they have an option, if they have an avenue, that we could do a roadmap that makes the most sense to people who are not lawyers, and even to people who are lawyers. The next area was the forcible entry and detainer, FED, undertakings for appeals to a circuit court, and whether those should be tweaked, and why they are what they are, and whether it makes sense to change those in some way. The treatment of abolished local courts records, if there are records, and whether those would go to the circuit court, or whether those would be retained by a county that originated the justice court, or to a city that originated the municipal court, or someplace else. And then the fifth issue was the efficiency of service requirements on district attorneys, because they're not involved in all cases. And so figuring out a way to codify, if it can be codified, and then to be able to identify that for litigants so they know who needs to be served with what. And then another issue was the option for local courts to become courts of record. And that's one where we may need to really look at who the stakeholders are, because they're just, in my non-layperson's view of that involves a certain price tag that I don't want us to make a recommendation that the people who might be paying that price tag are looking at us like, what are you thinking? So that's something that we want to look at that. And then there were a couple of other kind of ancillary issues. I know one of them was raised by John DiLorenzo, who was asking us to look at whether we should recommend or require the city of Portland to have a municipal court. And that's not in the charge of the work group, but that's one of those ones that came in this way from an OLC member. And then there was another one that Jim, I know you raised, and my notes on that are not as descriptive as I think you could probably tell us. There was another ancillary issue that you wanted us to consider taking up, and I think it was you, Jim. So I don't want to put you on the spot, but if it was, I invite your input here.
Yeah, I'm not I'm not remembering that.
Okay.
But at my age, that's not unusual.
It might be something Amy knows what I'm talking about.
I think you're talking about Rep. Wallen's question about the training and oversight of non-lawyer judges. That was the other one that came in. Yeah.
I'm sorry, Representative Wallen, that is exactly right. And then, yeah, please go ahead.
No, I was just gonna say that the other part of the proposal was if there were unintended consequences from 2460 that people identified between now and August, that this is also a potential forum for that. I talked to the OJD folks this morning. Thank you, Kimberly and Lindsay. And they did make the very valid point that it hasn't gone into effect yet. So we don't really know what's going to happen once January 1 hits, but that is also out there as something to pay attention to. And if we're the correct venue for that conversation, then that is also within the scope of what we can look at.
Right. Okay. Yeah, that's like a potential parking space that we might need to look at what's there.
Exactly.
Any questions or comments on that sort of concept of where we're asked to place our passion and our expertise?
Well, on the issue of on the topic of issues that may arise from the bill itself. In the course of a conversation with a friend of mine about the bill, the issue of transfers from local courts to circuit court came up, and the question was, can a person transfer a violation? And under the law, under longstanding law, only a misdemeanor can be transferred. But I think, although it's fairly rare, I think it's possible for both a violation and a misdemeanor to be charged in the same action. And the question is, if you can transfer the misdemeanor, then what happens to the violation? The other thing is that the bill itself permits in both misdemeanor and violation cases for the case to be transferred to circuit court if the trial court denies a pretrial motion. And so it's possible under the bill for the first time that a violation case could be transferred. And so whatever rules apply to appeals in those cases, we should make it clear that same rule apply to violation cases, regardless of whether it's heard in the local court or in the circuit court. So I mean, that's way down in the weeds, but that's kind of one of those issues that at least I never thought of when we were working on this bill the last time around, but kind of popped out to me when I looked at the bill in response to talking to a friend of mine about how this bill will work.
Okay. Thank you. Okay. And then at this point,
Judge James, I think Judge Cross has his hand up.
I'm sorry, Judge Cross.
Thank you. I was going to say Jim, I think what the problem, if you have a misdemeanor in a violation on in the same case, and the misdemeanor gets transferred, I would assume that the violation go with it, because that makes the most sense, and I think most judges would do that. If we need to codify something to that effect, I think that's not that hard to do, but I don't think it really happens that often. So I think we need to find out if it's really an issue. What comes up in my court more, because the DA's office in my county does not file misdemeanors in my court, because it's a 20 or more minute drive from their office to get here. It's just not something that they want to do, which is fine. But sometimes there's a misdemeanor case that's in the circuit court, and then the violation gets filed in my court. And if a defendant comes to me with that issue, I'm happy to transfer it to the circuit court if the circuit court will take it. And that's the one problem we have that might need some addressing, because in the Washington County, if the circuit court has already arraigned the defendant on the misdemeanor, they won't take the violation. Which is bizarre to me, because they could just arraign that defendant on that violation at their next misdemeanor appearance, for Pete's sake. So it doesn't make any sense to me. So oftentimes what happened is that violation might wind up getting dismissed, or we simply set it over until the misdemeanor case is dealt with, and then we essentially do an ad hoc resolution based upon what happened in the misdemeanor case. That's what I do. But I'm an old criminal defense lawyer, and I did that for 25 years before I became a judge. So I'm kind of sympathetic towards that. And when the circuit court won't take it, I get a little offended. But in any event, I think that particular issue might need some addressing if there's similar things that happened in other counties. I don't know.
That's really a good point, Judge. I know in circuit court, we get a lot of cases where we have a misdemeanor and violation. Basically, the violation tracks the misdemeanor and then is always resolved by the time the misdemeanor is resolved.
It should happen.
It should happen, and maybe if there's not a way for it to be required to happen that way, then maybe that's the way. Especially if they arise out of the same, occurrence. It doesn't make sense, and it's also confusing for litigants to not know, like, I have to appear in this court on this day on this violation, and then I need to be in circuit court on this day on this misdemeanor that is the same as the violation, except there's more to it. and more consequences. And a lot of times people will confuse their court dates, and it can really be a disservice to the litigant and really to the justice system to have it split.
I have a court-appointed attorney in the circuit court case, the misdemeanor case. That person, that outfit's contract, I will almost guarantee you, does not cover them doing the violation.
Right.
And therefore they don't, it oftentimes doesn't get into their into their equation if it's not filed in the same court at the same time.
Right. Right. Okay, well, that's something we sure could look at.
And oddly enough, this same dichotomy affects the appeals from circuit court, because if the defendant is convicted of both a misdemeanor and a violation, the appeal of the violation will proceed as an appeal in a civil case under ORS chapter 19, but the misdemeanor will proceed as an appeal in a criminal case under ORS chapter 138. And so that's another one of these little kind of technical things I'm hoping that we'll be able to fix.
Okay, well, we'll sure look at it. Melissa, Franz.
Thank you, Judge. I just wanted to briefly touch on Rep. Wallen's concern. I know that back in 2015, there was a House bill that was passed that addressed this issue. I don't know that it fully encompasses perhaps what is needed, but it was House Bill 3399. That was 2015. And at least as it relates to municipal court judges, that was codified in 221142. I don't know about the justice of the peace counterpart, but at least that could be something, a starting point, at least just for while we've been talking about it, that we could make notes of that.
Thank you. That's Judge Dan.
So there is a training requirement for justices of the peace who are non-lawyers. It involves the 2-week program at the National Judicial College, and I can't remember what the time. It has to be done every so many years. So number one, there's that. Number two, I'm not so sure that the justices of the peace are not covered by the Judicial Fitness Commission. I don't know if there's ever been any. I'm not aware of there being any appellate case law on that topic, but in my opinion, I think they could well be covered by the Judicial Fitness Commission. And number three, I will tell you that the Oregon Judges Association puts on what amounts to two full days of training every year, and then ODOT traditionally has another one works to be about 2 days of continuing legal education time. I would tell you that then the non-lawyer justices of the peace are, they attend those routinely. And fourthly, I get non-lawyer JPs that reach out to me frequently with regard to questions and legal issues, and they are very receptive to having those conversations. They do a lot of hard work to make sure that they're up to speed and that they're trying to follow things, and they're very, in my experience, the vast majority of them are very committed to doing that, to doing the right thing, and are very receptive to if something is not going the right way, to amend whatever the practice would be. And I just think it's important to point those things out. And it's the last thing I'm going to say on this is this particular topic is not within the scope of this bill whatsoever. And I don't know if this is the appropriate process for that.
Okay, thank you. Well, that's certainly something we can take a look at and decide whether, as I said, these other issues are things that we really do have to say, are we the right people to make recommendations on this? Is this within our charge? So we'll take a look at all of those and see which ones fall inside and which ones we may need to refer to another organization. I mean, what comes to mind for me right away is whether the bar is looking at this or has looked at this from the standpoint that they've done so much work with paraprofessionals serving, representing people, not as lawyers, not, as members of the bar, but as professionals who have their own, requirements, and that I'm wondering if there is a synergy there that may actually assist with this, with looking at this further, and looking into it. Scott.
So Scott Winkles from the League of Oregon Cities. And so I just want to clarify where the league is on this issue. And I think what we've said was that we've heard the complaints or concerns from other groups in the past, and we haven't looked at a bill. And I said, what we will do is we will analyze, we take positions on bills. And so when we see, a legislation coming forward, I think something we would want to introduce constructively, but we're not. We have a very strict process about how we pursue legislative objectives, and so it would be for us to. We don't have anything in the works right now on municipal judges. We will respond in this space when legislation, or when we start seeing proposals. So we're not proactively looking for legislation on this at this time. And I don't, but we are aware that people want to have that conversation, and we're always happy to talk about our courts and how they contribute to access to justice and to public safety in the state of Oregon.
Thank you. Okay, Amy, I'm going to turn it back over to you. How do you want us to, in addition, aside from, or in addition to figuring out dates and maybe talking about what dates we're working against that we know about, is how we want people to be able to weigh in on the various issues, and maybe see if there are some that we can address. I think we had looked originally at the FED issue and maybe the service requirements on district attorneys as sort of low hanging fruit that we might be able to look into and address relatively expeditiously, and then maybe need those work groups on some of the other more complex or thornier questions.
I actually ask Jessica to jump in before we start talking about that, just so she can talk about taking HB 2460 from a bill and inserting it into the ORS, so that everyone's on the same page on how that's going to work and the timeline for that. And then we can talk about next steps.
Very good. Thank you.
Of course.
Yeah, thank you. So for those who aren't familiar, Legislative Council is responsible for publishing the Oregon Revised Statutes. So at the end of every long session, once the governor has made the decisions on all the bills, we basically codify them. So we assign permanent numbers to permanent statutes. We, create editorial notes. We decide where things are going to be organized, that sort of thing. This process happens between August and November. And so that's currently what we're doing right now. I wanted to talk a little bit about where 2460 was codified, and then the timeline going forward of when you might see those numbers and when we can start actually drafting with our drafting software. So when the work group was meeting, there were some concerns raised about justice court statutes being kind of all over the place. So those have all been now consolidated within Title VI. And I'm just going to go through a very quick overview of how these are going to look. These decisions have been made, so I can't change anything now, but I really did my best to keep things very organized and logical. So Chapter 51 is just justice courts and jurisdiction. That is mainly unchanged. There were some new sections added to that chapter, and some of the statutes were amended. Chapter 2 was civil actions. That is where, a lot of that is unchanged as well. But the big change here is that Small claims, which previously resided in Chapter 55, has been moved to the end of Chapter 52. That was trying to avoid creating all sorts of different new chapters because there seemed to be a lot of space in that chapter. So now civil actions and small claims live together in Chapter 52. Chapter 53 used to be appeals in civil actions, and that entire chapter was repealed by 2460. Because that chapter was relatively short and there were many numbers available, that was prime real estate. And so all of Chapter 156, which was criminal actions in justice courts, have been moved there. So now there's nothing in Volume 4 anymore about justice courts. It's all going to be consolidated in one place. So again, Chapter 53 now has the contents of what used to be Chapter 156. Chapter 54 is juries. That was almost completely unchanged, I believe. And then Chapter 55, which is now empty because small claims was moved, that seemed to be the logical place to put all of the justice court appeal statutes. So that is where all of the appeals related statutes about justice courts are going to live from 2460. Regarding municipal courts, because everything was already in Chapter 221, that is where all the municipal courts statutes are going to live. And that was not my chapter. I didn't work on that, but I took a quick look at it. It looks like there's just like a new heading with appeals with the new sections under there. So hopefully that works for everybody. Obviously, if there's some huge error, maybe we could tweak it in 2027. But I really did my best, like I said, to make things logical and accessible. Because we're still in the middle of this process, things haven't been sent to the printer yet. I can't actually draft anything on drafting software until probably the end of November or early December. And that's because our software is updated with all the changes that happen once these chapters are finalized. If we needed to see draft language, I could create something in Word, but again, it would have to be redone in the drafting software. So realistically, I don't think we're in a place right now to be sharing work drafts at this point, but it would be best from my perspective to hold off on that until the end of November or early December. And then the actual new edition of the Oregon Revised Statutes will be published it's usually early January, and you'll be able to see all the numbers and everything. So let me know if you have any questions, but that's all I really wanted to cover from that perspective.
Thank you. That sounds like a lot more work than what you just made it sound like.
So with that in mind, there are a few logistical things to talk about. Excuse me. First, I think because of the limited window that we have, we do want to start having these conversations, and we don't want to wait, say, until after the short session or even until the new year. Like it would be good for us to start talking about this stuff on the front end. What Judge James and I had talked about was taking some of these things that were issues that were a little bit more self-contained and having conversations on the front end so that we could, some of the stuff that we're talking about is a little bit like an octopus, like their arms are reaching everywhere, which is a lot of what we had with 2460. Like you'd pull a string and the whole sweater would unravel. But what we're hoping to do is start with things that it can be a little bit more self-contained, and we can come up with where we want to go on the front end. And then once we have, Jessica's got everything in the software set up, then we can start working there. So our early conversation was perhaps this question about the FED undertaking, which Judge Cross and Jim Nass raised, and possibly the DA question about service might be something that we could talk about in November and December, because those are a little bit more self-contained. But we also want to be respectful of, like, for example, Monty, I know that this is your first time coming to this work group, and I don't want to like throw you in the deep end. So we're looking for things that we can kind of have that conversation with early, so that we can get started. Jessica can do what she can. We can have those conversations, and then that will also hopefully once we have the ORSs codified and available to us, we can start doing the drafting for some of the things that are more expansive. So I guess I'll start with the FED and see if Judge Cross and Jim, since you guys were the two that kind of came up with this, is this something in your mind that we could maybe talk about in November? And is this that we could kind of move forward on this one?
I think that that's probably the case, and perhaps even Jim and I could confer a bit and have some thoughts with regard to that. Obviously, they could get out in advance of that November session. Jim, do you think that's reasonable?
Sure. Although, I was a little bit surprised to see this on the list because we spent a fair amount of time on it, and I thought we had worked everything out. And frankly, I was hoping.
Oh, Jim, you just froze.
I was thinking that this is one aspect of the bill that was kind of new. We basically created this out of whole cloth, and we may have to see how it actually works once we start getting some cases heard to see if the statutory procedure is working the way we thought it was going to, or whether there were problems with it. But if someone has identified a problem with it, then absolutely, let's get to work on it.
I think my viewpoint was just the financial burden that could come on to many of these potential appellants, the tenants, and whether or not there might be some mechanism that would provide them with a relief from that. That's kind of the thought process I had, and I had a brief chat with Amy the other day about that. That's where I think we might need to address it. Jimmy, do you think that's already covered by what's in there?
Well, I know that on appeals from circuit court to the Court of Appeals, circuit court judges already have the authority to reduce or waive undertakings. It may be that I don't think there's a similar statute for appeals from justice courts to circuit court, so we may need to add that piece to it.
That's what I was thinking, and essentially to get relief for it's similar like in a criminal case where a person has an affidavit of indigency to qualify for court-appointed counsel, that there might be some similar thing we could do with regard to relief from undertakings in these FED matters. Anyway, let's maybe we have a little more chat about that, and again, betwixt you and I, and have something that we could maybe put forth as a conversation starter for the November meeting.
That sounds good, Dan. My question was, when I first saw that, was whether or not the undertakings are undertakings from obligations to pay for damage or do something like that, or whether the undertakings are actually for paying back rent or paying rent. And my concern is if they're undertakings for meeting a rental obligation, that we would need to involve some other shareholders.
Jim is our undertakings expert by far. Let me tell you. Yeah, I learned more about undertakings from Jim in the last few years than I ever wanted to know, and now I can't get all of it out of my head, and it haunts me at night.
So
yeah,
sorry, Jim, go ahead.
What's fascinating is that there have been many appeals and eviction cases from circuit courts to the Court of Appeals, and as the court's prior legal counsel and then later as appellate commissioner, ended up ruling on a lot of those motions to stay, which involve whether the person filed an undertaking. So there's a fairly well developed body of law and practice, much of it not even codified. It's just kind of what we've always done. But none of that applies, at least on its face, to this new procedure that we've created for appeals from justice courts to circuit courts. And in fact, I thought if the process worked well, this is something that some other group may want to look at, actually applying these same rules for appeals from circuit courts, because I thought it was a fairly well thought out process that attempted to balance the interests of both the landlords and the tenants and trying to be fair to both. So I do look forward to smoothing out any wrinkles in the current process that the statute has, although, as I said, I think it would really be helped by some actual practice.
Yeah, and some of the, by the way, some of the initial in these FEDs, there's I believe it's going to make that OJD is going to have a bill in the short session regarding the forms and kind of removing the templates from the current statutes and having it referenced that people should do directed to the OJD forms. And I think that's going to make, I don't know if that for sure, if that made the cut, but it looked like it was going to.
Okay, so maybe we can look at next month, having a better idea of whether or not there's a problem, whether this is a solution in search of a problem, or whether or not we've got it, we have a solution. We just need to understand how it's going to work.
I think that's reasonable. But I do think there is that issue for tenants who can't afford. I mean, most of the tenants, at least come through my court, can't afford undertakings of anything, let alone anything significant.
Okay.
Judge Cross, in any of the FED cases that you've handled, does the local legal aid office ever represent the defendant?
I haven't had that. I've had a couple of, I've had a few cases where where they have retained counsel and then the retained counsel moves to transfer to the circuit court. I'm now having a circumstance where because of the backlog and the time delay in the Washington County Circuit Court, we're getting some of the larger landlord outfits that are going to experiment, I think, with filing in this court. And so we're going to have a higher volume, and we'll see how that impacts these things. If so, we're crafting. If that's going to be the case, we're going to have that significant number after the little test run. We'll create new docket times to accommodate the volume. So I may have a better idea for you in a few months.
Okay.
What I can do is I can send out an email when I send out the recordings and the information on the roster, saying that Jim and Judge Cross are working on this issue, and if you'd like to participate in this conversation, reach out to me and I can coordinate folks. I know Heather couldn't be here today, but she is returning to this work group as well. So legal aid might be interested, and we could also reach out to Anna McCormick, who was so helpful on the landlord side, who was participated at the end of last time. And Kimberly, you have your hand up, so I wanted to just.
Yeah. Well, just a couple of things. Judge Cross, I sure owe you a phone call. But we are still deciding on the forms, whether or not we'll do it this session or in the next session. But I was just thinking, well, I just got a little bit confused. So are we going to have like a separate work group on this FED issue then, or are we going to talk about it in November?
We'll do both. We'll have a smaller conversation so that people can dive into the details. And if you're interested in that, we can do that. And then that smaller group will come back with a proposal or maybe a couple of options to say, hey, we did find this issue and these are some ways to address it. So it's going to be kind of a dual level, excuse my language. Does that help?
Great. That's super helpful. And then I had another question, which was just, for some of these issues, some of us were here, some of us were around and when conversations happened and some of us were not. And like for myself, I was involved in, I came in a year ago. So something that I'm familiar with and others I'm not. And I'm just thinking for like sort of just teeing up the issues. I don't want to create for you, Amy, necessarily, but like I'm just wondering if like for teeing up the issues for us, if it would be helpful to have sort of like here's the question sort of presented to the work group. This is the issue, and then like this is the conversation that's happened already, or like just some sort of summary of what the conversation is that happened already, so that we don't necessarily have to like recreate the wheel, and can all sort of start on the same page.
And yes, the answer to that question is yes. And that is one of the things that Karen and I will be doing. So we will get that information to you. Did Kimberly just drop off the call? I think she might have.
Still here.
I'm still here.
Oh, I don't see you. Somehow or another you dropped off my screen. Sorry.
And I was giving you praising hands.
Oh, okay. But we, yes.
Kimberly, I would say that some of that information on those discussions in the smaller group and kind of what the resolution was or it's not is contained in the OLC commission, the report. It's a lengthy report. I think it was probably something like 50, 60 pages long. But it is, some of that information is contained in there, and I would certainly reference that to you. It doesn't contain every single one, I don't think, by any stretch, but it's certainly a good starting point.
Thanks, Dan.
Yeah. So that's the FED issue. And then Monty, I don't know if you will be wanting to talk about the service question, or if you want to talk to Scott and Bill a little bit more, but that was the other one that we identified as potentially something we could at least have an initial conversation about early on.
Well, I'm still in the process of coordinating with Bill and Scott and get up to speed. And I just wanted to clarify, in getting thrown in the deep end, I thought there would be a life preserver provided.
No.
And I'm happy to work with you and Scott and Bill and Amanda on getting you guys up to speed as well, if that's helpful. Yeah, so maybe you and I will connect offline and figure that out.
I think it sounds good. I'll probably know more here in the next week or two.
Okay, that sounds great.
Amy, I'm sorry to jump in without raising my hand. Can you include us on that? Typically, the city attorney is also included on those service requirements.
Yes.
For calling.
Yes. And so, okay, I'm just aware of the time, and I had one other thing that I wanted to check in about, which is the roster. One of the things that OLC work groups have done historically is post their roster on the website for the different work groups, so that if someone has a question about it, what's going on, they can reach out. Oh, Melissa's the city prosecutor, and I have a city prosecutor question. I'll contact her versus, and you might have that pre-existing relationship. I'd like to do that again with this work group. It's something we didn't do last time, but I think it could be helpful. I'm going to send out a roster to folks with the recording materials and everything else we've talked about today that I'll be sending out. And if you do not want to be listed in a certain way, or I've misspelled your name, hopefully I don't do that, please let me know. And the plan would be to post that prior to the next meeting. So your names are just out there, so that if someone from OJD has a question, they can bother Kimberly or Lindsay and that sort of thing. So I just wanted to flag that would be coming out. And that's it for me for process stuff, Judge. So I will be quiet.
Okay, no problem. I think the other thing I was just going to ask in terms of if you could just remind us, Amy, of the Oregon Law Commission dates of import that we need to be aware of, so that when we're scheduling our meetings, we're meeting in a way that's productive to reports back to the full commission, and also sort of what our end date, launch date of next August might look like.
Okay. So the proposed meetings for 2026 have not been approved yet, but we are looking. We have a meeting this November 21st, and then we're meeting in March, June, September, and December of 2026. The goal is to complete our draft bill by the end of August, so Jessica can draft all of the other bills that she will be drafting for the 2027 session, because that is the deadline for legislators to get their requests in, and for those unlimited requests. So We will be done by the end of August. That will give Jessica a chance to draft everything else, and Kara and I, or whoever is taking Kara's role next year, to draft the report. The proposal itself will go to the commission, crossing all our fingers and toes that we get there, for the December 4th, 2026 meeting. And the goal there would be to pre-session file the bill at the December legislative days. And I don't think, I mean, you can know this better than I do, or maybe Jessica, but I don't think those dates have been released yet on when the pre-session filing deadlines are. But 2 years ago, it was the second week of December. So crossing my fingers that works for folks. And if not, we might have to move our December meeting, but that's the goal. So mid-November, that would mean the report would need to be completed by mid-November, and the bill would be completed by end of August, with any last minute tweaks having to be wrapped up by November. And of course, as you all gals, everyone who worked on this last time around or has worked legislatively, there's always the amendment process. It's not ideal. So if we do come across something that's a crisis at the last minute, we can fix it. But the goal is the goal is no crises. The goal is to get it done so that we don't eat up Jessica's fall with drafting bills. So I just want to let you know that we did have that option last time around of talking through some of these bigger issues. And I think that is in a huge part because Jessica was incredibly generous with her time. And I'm going to appreciate that forever, but know that I don't think we're gonna try really hard not to do that to Jessica again.
Right.
So
thank you for that. Okay.
Yep.
And then if you can send out dates for us, Amy, on future monthly meetings at least. And I do welcome people to reach out independently or informally, I should say, to identify areas that you would like to be particularly involved in. And if you can let Amy know that, there's a possibility that we could start working on some of these other issues as soon as November, but at no later than December. So if you don't mind doing that, if you can go in the report, I think it was page 11 of the report that talks about the recommendations to continue addressing issues. And so if you can take a look at that and then just let Amy or myself know any of those additional issues that you might like to be particularly plugged into. I think that'll help us be able to sort of streamline our conversations going forward and to make some real progress. And with that, if there's anything else for the good of the order, I welcome it now. And otherwise, I will accept a motion to adjourn.
I move we adjourn.
And a second.
Second.
All right. Moved and seconded to adjourn. I don't know that we need to vote on adjournment, but I'm going to declare that we're adjourned. Thank you all so very much. I look forward to working with you. Have a great rest of your day.
You too. Bye.
thanks, everyone.
All right. Bye.